Let's now begin with chapter 2. In chapter 2, we are going to understand how is a company incorporated and what are the different things, what is the process of incorporation, the procedure, different documents which are to be made, and the matters which are related to the incorporation of a company. So in chapter 1, what did we do? We have understood the basics. We have understood a few basic terms. And now we will start with a very important topic wherein we will understand how is a company incorporated. Let's understand what is incorporation of company, but let's first take an example and let's first understand as to what are the basics for incorporation of a company. So let's say there's a person, Mr. Raj, and Raj wants to incorporate a company. He wants to incorporate a company. Now, what is the very first thing which Raj should have in his mind? The very first thing which Raj should have in his mind is a business idea. As said, an idea can change your life. So, similarly, Raj should first have an idea. What are you going to do? Simply establishing a company, simply incorporating a company? Nothing. You should have an idea as to what business are you going to do, whether it is a legal business, whether you can do it as per law or not. All of the things have to be checked before you incorporate a company, because if you do not have any business idea, what are you actually going to do after incorporating the company? That becomes the question. So the first thing which Raj has to have is a business idea. So what is the business which he is going to do after incorporation of a company? So let's say Raj has thought of a business idea and he wants to establish a manufacturing company. Alright, no problem. Now that Raj has a business idea, he can go and incorporate a company himself. No, Raj will need some capital. Raj will need some members in his company. So he'll need people in his company. Not only business idea, he'll also need people to start the company. Now again, number of people required will depend on what type of company Raj wants to start, whether it is a public, private or one-person company. If it is a one-person company, then no problem, Raj can himself start the company. However, if it is a public company or a private company, for a public company, Raj will need minimum 7 people. For a public company, Raj will need minimum 7 people, and for a private company, Raj will need minimum 2 people. If it is OPC, then only 1. He can himself start with the company. So this is the first thing. Raj, after getting an idea, he'll first have to sort the number of people he requires to incorporate the company, to start the company. So if it is a public company, minimum 7 people would be required. A private company, minimum 2, and one-person company, only one person can himself incorporate the company. That is one thing which is done. Now, after he has decided upon the people, he'll also have to see that how much money is required to start the business. See, no business can start without money. There'll be some amount of capital required. So he'll have to ascertain as to how much capital is the company going to raise, what is going to be the share capital of the company. He'll have to check what should be the share capital of the company. Which share capital am I talking about here? I am talking about the authorized share capital. Authorized share capital, in simple terms, is the maximum amount which the company can raise by way of issue of its shares. So Raj will now also have to determine what will be the authorized share capital of his company. So Raj first has to get an idea, he'll have to get people along with him, he'll also have to bring in money. Now money will be brought in by all the members of the company, whoever is purchasing the share, whoever is subscribing to the securities of the company, they will bring in the money. So the capital requirement also has to be sought by Mr. Raj. Then he'll also have to check that who is going to control the management of the company, whether he'll do it himself or he's appointing some other people to manage the company. After all of this, he'll also have to file up the documents with the registrar of companies, and after the registrar is satisfied with the documents which are filed with him, the registrar will either incorporate the company, or if he is not satisfied, he will not incorporate the company. So the process of incorporation of company is a big one. You can not incorporate a company in one day. It is not possible for any person to incorporate a company in one single day. There is a process which has to be followed. All the documents have to be made, all the documents have to be submitted to the registrar of companies, and only then the registrar will incorporate your companies. So, when we talk about incorporation, what is the first requirement? An idea which is going to be your business, an idea on which you are forming the company. So here, who is the person who is getting this idea? Mr. Raj. There is one term given to Mr. Raj, a person who gets this idea, a person who conceives the idea of a business and he takes steps for incorporation of company. That person is called as a promoter of the company. So a person who gets the idea and who takes steps for the purpose of incorporation of the company, he is said to be the promoter of the company. So in our example, who is the promoter of the company? It is Mr. Raj. Raj is the promoter of the company. Now let's understand what is the meaning of promoter. What I've explained you is in a layman's term. However, there is a specific definition of promoter given to us under section 2. So let's first understand who is a promoter of the company, defined in section 2 clause 69. So who is a promoter? Now 3 things to keep in mind. 1, he is a person who is named as a promoter, in the prospectus of the company. A person who is named as a promoter in the prospectus of the company. Named as a promoter in the prospectus means what? So prospectus is basically a document which is like an advertisement, which is like an invitation to the public to come and subscribe to the securities of the company. So prospectus contains details of several things. It will also contain the detail of the people who are behind the incorporation of the company. Why is that information required? See, if you want to invest in any company, what do you check? You check what is the business of the company, you will check who are the people who are running the company and all of those details. So similarly, in the prospectus, we have to give the name of the promoter as to who is the person behind the incorporation of the company. So who is a promoter? 1, a person who is named as a promoter, whose name is written as a promoter in the prospectus of the company. So that is 1. Second, he is the person who controls the affairs of the company either directly or indirectly. So controls the affairs of the company directly or indirectly. So who is a promoter? 1, who is named as a promoter in the prospectus of the company. 2, he is controlling the affairs of the company either directly or indirectly in the form of a shareholder or member of a company or management of a company. So what is the promoter doing? He has control over the affairs of the company. Apart from it, what else? Who else will be termed as a promoter? He is a person according to whose instructions the board of directors of the company do take their decisions. So according to whose instructions the board acts or board takes actions. Alright, so who is a promoter? A person who is named as a promoter in the prospectus, or anyone who is controlling the affairs of the company either directly or indirectly, or any person according to whose directions and instructions the board of directors of the company are doing their work, are taking their actions. So that person is said to be the promoter of the company. So who is a promoter? Let's have a look at the definition of promoter. So section 2 clause 69 defines a promoter, which means person who has been named as such. Named as such means named as promoter in the prospectus, or is identified by the company in the annual return in section 92. So if he is named as a promoter in the prospectus or identified as a promoter in the annual return, or who has control over the affairs of the company either directly or indirectly by as a shareholder or director or otherwise, or in accordance with whose advice, directions or instructions the board of directors of the company is accustomed to act. So in accordance with whose advice, directions or instructions the board of directors of the companies are acting, that person is said to be promoter. However, this clause C shall not apply to a person who is acting in professional capacity. Now say for example, if your company has appointed a lawyer. Now lawyer is a person who is providing advisory services to the company. If a lawyer gives an advice and the board of directors are following the lawyer's advice, here the lawyer will not become the promoter of the company. He will not become the promoter of the company. The lawyer is acting here in his professional capacity. So when a person is acting in his professional capacity, he cannot be termed as a promoter of the company. So the definition of promoter excludes the person who is acting in his professional capacity. So if a person is acting in his professional capacity, then in that situation, that person will not be referred to as a promoter. So excludes person acting in professional capacity. So a promoter does not include a person who is acting in his professional capacity. Could be a lawyer, chartered accountant, company secretary, anyone who is just giving instructions, who is just providing some advisory services as his duty as a professional. Then that person will not be treated as a promoter in the company. Now let's move ahead to the next section, section 3, which talks about formation of a company. Now when we talk about formation of a company, what is the basic requirement? Number of members, minimum number of members. So in order to form a company, what are the minimum number of members required? Let's see. So section 3 subsection 1 talks about the minimum number of members, and what does it say? It says company may be formed for any lawful purpose. Now here the word used is may, but it shall be read as shall, because what happens is if we go into the rules of interpretation and interpret this, using the word may gives an other option. So here there is no other option. You cannot form a company for any unlawful purposes. No, your company shall be formed for lawful purposes only. So here the word may shall be construed as shall. So a company may be formed for some lawful purpose. So whenever we are incorporating a company, it should be for any lawful purpose only. By how many members? By 7 or more persons, where the company to be formed as a public company. So public company, 7 or more persons. 2 or more persons, where the company to be formed as a private company, or 1 person where the company to be formed is a 1 person company. How will they become the members? By subscribing their names or his name to the memorandum and complying with the requirements of this act in respect of registration. Now here the term which comes up is subscribers to memorandum. Now this is a term which will come at several places. Now, who are subscribers to the memorandum? Subscribers to memorandum are basically people who are the first persons to sign the memorandum. The persons who are going to sign the memorandum of association and who will become the first members of the company. They are the people who are going to become the first members of the company. And when we say first members, each person who is signing the memorandum will also have to take at least one share each. At least one share each. Now say Raghu and Ram, they are starting a company. When they are starting a company, they are taking all the steps for incorporation of company, they are making all the important documents with respect to the company. So when the memorandum of association is made, what is a memorandum of association? The charter or foundation of the company. The most important document of the company is the memorandum of association. So here Raghu and Ram, what are they doing? They are the people who are incorporating the company. They are the people who are taking the steps for incorporation of company. So what they do, they are the ones who are going to sign the memorandum of association. So here Raghu and Ram will become the subscribers to the MOA. So subscribers to MOA are who? They are the people who are the signatories to the memorandum of association. They are the ones who will become the first members of the company. So here it says, how will the people become the members in a company? By subscribing their names to the memorandum of association and also complying with the requirements for registration of company. So this is what section 3 talks about. Section 3 gives us the minimum number of members required to incorporate a company. So it is 7 for a public company, 2 or more for a private, and 1 person for a one-person company. Now, there are different types of companies on the basis of liability. What are they? On the basis of liability, company can be divided into 3 types. This is something which we have already seen in section 2 under definitions. On the basis of liability, company can either be a company limited by shares, or a company limited by guarantee, or an unlimited company. So on the basis of liability, company can either be classified as company limited by shares, company limited by guarantee, or an unlimited company. So what is a company limited by shares? Here the liability of shareholders is limited to the extent of unpaid value on the shares. So in case of a company limited by shares, the liability of member is limited, however to the extent of unpaid value on the share. In case of company limited by guarantee, what happens? Some of the shareholders agree to take up an extra guarantee to pay an extra amount at the time of winding up. So here the liability is limited, however to the extent of agreed contribution. And then there is unlimited company. So shareholders who have agreed to take unlimited liability will bring any amount of assets in order to satisfy all the liabilities and the payments of the shareholders at the time of winding up. So basically this is a situation where the liability of members in the company is unlimited and their personal assets will also not be safe in the case of winding up of the company. So if required, they'll have to bring in their personal assets also in order to pay off all the debts and liabilities of the company. So on the basis of liability, the company is categorized into 3 types: company limited by shares, company limited by guarantee, and an unlimited company. So these are the different types of companies on the basis of liability. Moving ahead to another very important type of company, which is a one-person company. Now this concept of one-person company was brought in from Companies Act 2013 only. Earlier, there were only two types of companies, public and private. However, this concept of OPC was brought in with the Companies Act 2013. What was the main intention behind bringing this concept? The main intention behind bringing the concept of one-person company was that people are encouraged to become entrepreneurs. So in order to encourage entrepreneurship in the country, and also in order to help people establish a company form of organization, even if they are sole proprietors, even if they are the single members, the concept of one person company was brought in. Now what happens? Generally, if you are alone, you are the only person who has to start a business. What happens? You start a sole proprietorship. Now what is the biggest drawback of sole proprietorship? Unlimited liability. Your personal assets are also not safe if you are starting a sole proprietorship. So this company form of organization helps you get the benefit of a company form of organization and also enjoy the perks of being a sole proprietor. One person company was established in order to encourage entrepreneurship and also to help small proprietors to upscale their business. So that is the reason why the concept of one person company was brought in. Now when I talk about a one person company, as the name itself suggests, there's only one person who is the member of the company, only one member in the company, and that one member will be the director of the company. Now talking about a one person company, since there's only one person who is the member. Now let's say Mr. Karan is the member of a one person company. Karan has started the company, he is the member in a one person company. Now when Karan is incorporating a one person company, like all the other companies, here also a memorandum has to be made. A memorandum has to be made in case of one person company as well. So there's one specific clause which comes up in the memorandum of association of a one person company, which is called as the nomination clause. Now what does the nomination clause says? Now since in case of a one person company there's only one member, what will happen if the member dies? What will happen if the member becomes incapacitated? What will happen if the member is no longer able to operate the company? Who will take over the company? Who is going to look after the company? So in such a situation, what is the member of a one person company required to do? So the member of a one person company is required to nominate a person as his nominee. Now nominee is basically a person who will become the member in case of death of the member of one person company, or when the member becomes, in case of incapacity of the member of company, it is the nominee who will take over the one person company. So this clause, nomination clause in the memorandum of association of the company, states the name of a person who is appointed as a nominee in case of the one person company. So nominee, who is the nominee? He is the person who will become the member in case of death of the member of one person company, or in case of incapacity of the member. Now when a person is being appointed as a nominee, one requirement here is his prior written consent. So let's say Karan is appointing Ruhi as his nominee. So in this situation, Karan will have to first obtain a written consent from Ruhi, and only then he can appoint her as his nominee. Now say the company has been incorporated, Karan has appointed Ruhi as his nominee. However, there can be two situations which may arise here. One, Karan wants to remove Ruhi as his nominee and appoint someone else. So one is member wants to change nominee. Or second situation could be where Ruhi herself wants to withdraw her nomination. So Ruhi wants to withdraw her consent for nomination. Now what will happen in this kind of situation? So if the member wants to change the nominee, if Karan wants to change Ruhi as his nominee and appoint someone else in his place, let's say Karan is now appointing Mr. Rohan as his nominee in place of Ruhi. So Karan will what? He'll have to give a written notice to Ruhi, a notice in writing to Ruhi that he no longer wishes to continue with her as his nominee, and he'll have to obtain written consent of Rohan. He'll have to send a written notice to Ruhi and obtain a written consent from Rohan that he is willing to be appointed as a nominee. And whenever this change is done, Karan will also have to inform to whom? He'll also have to inform all of the change to the registrar of companies. Now talking about Ruhi herself withdrawing her nomination, can she do this? Yes, she can withdraw her nomination by giving a written notice to Karan of her intention to withdraw her nomination, and then once Ruhi withdraws her nomination, Karan can appoint someone else in her place. And whenever a new person is being appointed, Karan also has to make sure that he obtains a prior written consent from the new nominee as well. So this is how the nominee is appointed and can be changed. Now talking about who can become a member and a nominee in one person company. Who is eligible to become a member as well as a nominee in case of a one person company. Now the criteria given is only a natural person. Natural person means what? A human being, a person who has taken a natural birth, which means what? Company cannot form a one person company. Only a natural person, a person who has taken natural birth, is eligible to incorporate a one person company. So first criteria, only a natural person. Second, Indian citizen. So this natural person also has to be the citizen of India. Citizen of India as per the Citizenship Act. So natural person who is an Indian citizen, whether resident in India or not. Whether resident or not. Earlier, residential status was also a mandatory condition. However, now it has been made an optional condition, which means what? Foreign nationals who are Indian citizens who are foreign residents, they can also come and incorporate a one person company here in India. So what is the first condition? The person has to be a natural person. Second, he has to be an Indian citizen. Is residential status mandatory? No, it is not mandatory. He may or may not be a resident in India. Residential status is not mandatory in order to become a member or a nominee in case of a one person company. So only a natural person who is an Indian citizen, whether resident in India or not, is eligible to become a member or a nominee in case of a one person company. And when I talk about residential status, who is said to be a resident of India? A person who has stayed for 120 days or more in the immediately preceding financial year. So resident is basically a person who has stayed in India for 120 days or more in the immediately preceding financial year. However, this residential status condition is not mandatory, it is optional. So what did we understand? We've now understood that who is eligible to become a member and a nominee in case of a one person company. Now another important point here is that a person can become a member in only one OPC, and he can become a nominee also in only one OPC. So say for example, in our example, Raj has incorporated a company A Private Limited, which is a one person company. So Raj is the member of A Private Limited. Raj is a member of A Private Limited. And Raj is also appointed as a nominee in another one person company, which is X Private Limited. Here Raj is a nominee. So he is a member of A Private Limited and is a nominee in X Private Limited. Allowed? Yes, allowed. He is a member in one person company and he is a nominee in one person company. No problem with this. However, let's say the member of X Private Limited dies. Now, if the member dies, who will become the member here? Now, Raj will become the member in one X Private Limited because the person who was the member of this company has died. As a result of which, what has happened now? Raj was already a member in A Private Limited and now, because of his position as a nominee, he now becomes a member in X Private Limited as well. Condition violated, condition contravened. So in such a situation, what can Raj do? Raj will either have to resign as a member from this one person company or X Private Limited. So Raj will have to take corrective actions within 180 days from the date when he becomes the member in X Private Limited or from the date where the condition has been contravened. And similar thing applies in case of nominee as well. A person cannot become a nominee in more than one person company. He can be a nominee in only one person, one OPC. So member in one and nominee in one, allowed, no problem. However, member in two one-person companies or nominee in two one-person companies, not allowed. So these are certain provisions with respect to one-person companies which are very important, and any change happening in the OPC, information has to be given to the registrar of company, whether the change in nominee, whether the change in member, whatever it is, whatever type of change is happening, the information has to be communicated to the registrar of companies. So let's now have a look at the provisions with respect to one-person companies. So who can form a one-person company? Only a natural person, and an Indian citizen, whether resident in India or not. Natural person, Indian citizen, whether resident or not. Who is resident? A person who has stayed in India for not less than 120 days, that is greater or equal to 120 days during the immediately preceding financial year. That person is said to be a resident in India. Now, the memorandum of one-person company shall state what? The name of nominee. The MOA shall state the name of nominee and along with his written consent. Nominee can withdraw his consent by giving a written notice. The sole member must nominate another person as nominee in 15 days. So, as and when the nominee withdraws his consent, what will happen if the nominees withdraw his consent? The member will have to appoint a new nominee in 15 days. In the next 15 days, the member will have to appoint another person as his nominee. Then, member may also change the nominee at any time for any reason, and he'll have to give a written intimation to the company about this. Where the nominee becomes new member, then such new member shall nominate within 15 days a person as his nominee. Now say a person becomes a member by a virtue of him being the nominee. So nominee has become the member of the company. Nominee himself has become the member, so now there is no nominee. So when the nominee becomes the member, he shall appoint his nominee in next 15 days. So in the 15 days, he shall appoint a person as his nominee. In case of withdrawal, replacement or becoming a member of the the company must inform registrar within 30 days by filing INC 4. So in case of withdrawal of nomination or replacement of nominee, or where a person is becoming the member of a one-person company, the registrar of company shall be informed in 30 days. And in which form? In form INC 4. The registrar shall be informed about the same. Then, if a person becomes a member of another OPC as a nominee, they must ensure that they are member of only one OPC within 180 days. So within 180 days, like I told you, the corrective action shall be taken. That is what this particular point talks about. And also, one very important point is that an OPC cannot be incorporated as a Section 8 company, and OPC can never be incorporated as a Section 8 company, and an OPC can be converted into a public company or private company at any point of time. Can be converted into public company or private company at any time.